Good afternoon, everybody. My name is Chris Justice, and I am here again to join you with a view of answering as many employment law related questions as I can in the half hour. So please do get your questions in. As many of you may know, I'm working out of Samfiru Tumarkin's Toronto offices. And as I say, whether you've got questions regarding something going into a working relationship, maybe something you're dealing with during a working relationship itself, or you have some questions on your way out or after having left a particular situation, feel free to get your questions in now. And as I say, I'll do my best to answer as many as I can within the time permitted. As I usually do at the beginning of each session, I like to talk about some trending topics, some things that are in the news, and or some things that have sort of come across my desk more recently. The first thing I wanted to actually talk about had to do with a story involving Wells Fargo. Now, this company is expecting further layoffs in an attempt to improve efficiency amid a commercial real estate slump. So as a result of the slump itself, and the decision from Wells Fargo, a number of employees are going to be laid off or have been laid off. And I thought it would be a good opportunity to sort of discuss in general what somebody should be looking at when it comes to their employment being terminated, whether it's for economic reasons or otherwise. So if you're an employee of Wells Fargo or you're an employee of any company for that matter, and you're part of a series of layoffs or you've just been let go, you want to know that potentially you could get, as an employee, severance-wise, as much as 24 months of severance. That's generally the most an employee can get in this country, in this province. And it will come down to a number of factors, many of which you know already, but those factors are the age of the person at the time they're let go, the position that that person held at the time they were let go, and the length of service that that person had at the time that they're let go. And as well, the availability of other work that is similar to that job that's out there in the job market. So those are the main factors the courts will look at when trying to assess how much somebody should get. Typically, if you're someone in the age bracket of 55 and up, you're going to get in general a little bit of a bump when it comes to your severance entitlements. Based on the notion that those of an older age may have a harder time to find work, may suffer some prejudice on their way to trying to find another job or some form of replacement income. So that's partly why the age is there as a factor. Typically, as far as length of service is concerned, the longer somebody's with a company, generally speaking, the more severance they're going to get. However, if you're somebody who's in a situation where you have been at a company for a relatively short period of time, so it could be a year, could be two, could be three, or even less than a year. You may think initially that you're only owed a week or two or maybe a month, but actually there's a lot of case law out there that suggests that employees who have short service, so 1, 2, 3 years of service, let's say, tend to get disproportionately larger packages. So you'll often find someone with maybe a year or two of service getting 3, 4, 5, 6 months of severance, which is probably 2 or 3 months for every year they've worked. And so, again, just a little bit of a misconception or misunderstanding when it comes to short-term service employees. Don't think that you're automatically looking at a very low amount of severance. It could actually be very beneficial for you financially to kind of pursue more severance, depending on your situation. And then the position that you hold, I mentioned, was one of the other main three factors anyways. So if you're somebody who's making minimum wage, in theory, it should take you less time to find a job that's comparable versus somebody who might be a president or CEO or VP or an executive of some sort, with maybe a lengthier interview process, and the time that actually takes from the day you apply to getting the job might be longer. So that's obviously the main basis behind the position itself, how many are out there like the one you had. But as I say, you can get upwards of 24 months. Most employees who are let go, whether it's part of a mass layoff or otherwise, are not typically going to get a fair package from the get-go. In most cases, whatever you do get offered by your employer, as fair as it may seem, as generous as it may seem to you, in most cases, it's not fair, it's not generous, and it is very much in your interest to get a lawyer involved, get some legal advice so that that lawyer can advocate on your behalf and so that lawyer can get you the maximum severance possible. Because otherwise, unbeknownst to yourself, you may be throwing away tens of thousands, if not more, in severance that you could have got. And so another point I want to raise as well, if you are somebody who's been let go, whether at Wells Fargo or elsewhere, you want to not sign any contract. Don't sign any full and final release. If the company's asking you to sign something, before you sign it, 100% get legal advice, talk to a lawyer, because once you sign it and you accept a package that you may think is generous, it's very difficult, if not impossible, for you then to go later on back and try to reverse the damage that's done. So that was one of the topics I wanted to talk about at the top of the show. The other one I wanted to bring up had to do with a purchase and sale that took place recently involving Rockwell Automation and ClearPath Robotics. So Rockwell essentially acquired ClearPath as part of a broader acquisition. And a lot of people in these circumstances come to me and ask me, Chris, I used to work for this company, but it's now been sold to another company. What happens to my employment? Am I going to be continuing on working with the buyer of the business, the new company that's come into the fold? Will I get a severance package from the seller, the employer that I've been working with all these years? Do I have to join the buyer? What happens if I just leave the company after this purchase and sale takes place? So these are all, very important questions, relevant questions. And as far as an employee whose employment ends when a purchase and sale happens, so say you're working for one company, they get bought out by another, and then the company that buys the company out does not want to keep you on as an employee, then typically you're going to be looking to get your full severance from the company that sold the business, that was the last employer that you worked for. So that's who you would go after in that sort of scenario. There are also other scenarios, like I say, where somebody stays with the company, the purchaser of the company. They don't leave and they just get brought on board, and they basically, in most cases, do the same thing they were doing before. It's just a different company's now paying them. There's a different name on their paycheck. And in those cases, if you're an employee who sort of transitions from the seller to the buyer of the business, first of all, you want to make sure that you're not signing any new contract that the buyer may put in front of you. So in this case, if Rockwell is buying out ClearPath and Rockwell decides to keep you on as an employee of theirs, they may give you a contract they want you to sign, and they may tell you that it's just a formality. They may say, look, nothing's going to change. You're just going to continue doing your job. It's just we're going to be your employer now, and we're going to be the one paying you. But day to day, your job's the same. You may think, okay, it's fine if I sign this contract or this document. It's just a formality. But unbeknownst to you, there may actually be some fine print in that contract that could have very severe ramifications on your status or on your future as an employee. Because there could be some language in there, for example, that does not take into account the seniority that you had with the seller. So you may think you're getting your seniority to continue, and the purchaser of the business is looking to sort of start fresh and discount all that prior service. So that's one thing you want to look out for if you're transitioning from a seller to a buyer in these kinds of situations. The other thing too is they may put in some fine print into a contract that talks about termination. So there could be a scenario, for example, where your business gets, the company you work for gets bought out, you stay on with the buyer, you sign a contract, you get let go by the buyer later on down the road, and you find out that that contract you signed with the buyer has some fine print in it where it says, if we let you go ever in the future, we're just going to pay you a very little amount of money. And that may not have been something that you had in place with the seller of the business. And it could have a huge effect in terms of your severance, even if all of your years with the seller of the business are taken into account. So these are just a couple of examples of aspects of contracts that the buyer may ask you to sign on that you'll want to get some legal advice before doing so. And then there's also a situation where if you're an employee and you're working for a business and they get bought out, and then the employer who buys them out wants to keep you, but in order to keep you, they're trying to change a number of the terms of your employment around. So they may say to you, look, with the previous company we bought out, you were working 9 to 5, but now, we're the new owners and we want you to work nights, or we want you to work weekends, or we want to change your title or drop your pay. I mean, there are certain things that the buyer of the business may propose to you. And if you say no, you may actually be within your rights to reject those terms. And if they're not accepted because they're very different than what you were used to, you may still be able to collect severance from the seller of the business, from the employer that you would have worked with before. So these are the three main scenarios that sort of often come up when it comes to purchases and sales. But again, all the more reason why you should be getting legal advice if you're in this scenario, if you're considering staying on with the buyer, or if you're considering maybe accepting changes to your employment that are going to be applicable to the buyer that weren't with the company that you were with before. I'll get into some other topics that I wanted to talk about regarding things that have come across my desk and have come about as of the news. But I do have a question in from Harinder on YouTube, who's saying that their employer has cut off their health benefits in January of 2022. Is there any way that they can get back their health benefits since they're still an employee with them, and how? And Harinder mentions that they've been working for their employer since 1996. So in general, when an employer makes a substantial change to your employment, that could be anything. It could be demotion, could be a decrease in pay, it could be cutting off your health benefits. If they cut off your health benefits through no consent of your own, without any input of your own, and sort of maybe in an arbitrary fashion, because I don't know exactly why they've cut off the benefits, but if they have cut off your health benefits and that's something you don't agree with, and it does represent a big change to the terms of your employment with that employer, then you'll definitely want to raise your objection if you haven't already. Typically, employees have up to 2 years to bring a lawsuit or some sort of claim against their employer for breaches of contract. And so if your employer has arguably breached your contract in January of 2022, one question would be, it's almost January of 2024. Has there been any discussion with your employer over the last almost 2 years about them cutting off your benefits? Because as I say, if you want to try and make an argument that your employer has breached your contract when it cut you off benefits in January of 2022, you're going to have until January of 2024, which is not that much time, to bring a lawsuit potentially over the loss of those benefits. But because it happened so long ago, and you're still an employee of theirs, you may be in a situation where you have condoned them doing this. And this is a concern that I tell people a lot. When it comes to an employer changing the terms of your employment, cutting you off benefits, decreasing your pay, moving you locations, changing your hours, you need to act fast. You need to say, as soon as you can, after getting some legal advice, of course, that you don't agree to them doing these things, that you do not consent to it, that you object to it. And then from there, you can pursue a claim if there is one. So Harinder, I think it would depend on how much communication has happened between you and your employer since January, which is about, over a year and a half ago. Have you raised your concerns? Have you objected to it? What's happened there? Because as I say, when companies switch things up on you, you don't want to be waiting a long time before taking action. The longer you wait, the more time that passes after an employer does something drastically to your employment, the harder it's going to be for you to go back after the fact and get it rectified. So Harinder, you may want to give us a call as soon as possible, because time is very much, or could very much be, of the essence. And we can happily set up a consultation with you, go through all the details, go through all the documents, review anything that might be of relevance, and at least give you an idea of all the options you have at this point, and sort of maybe what makes best sense in your particular scenario. But thank you for the question, Harinder. I've got another one in from Sam on YouTube, who's asking, if you aren't hired back for a seasonal position after several years of consistently working in the job, are you owed any sort of severance? And it's another good question, because a lot of people have some misunderstandings when it comes to seasonal jobs. So if you're somebody, let's say, who works every year, but you take winters off, and then that's the seasonal aspect of the job, and year after year after year, you get called back after the winter ends each season, then if there becomes a time or a year where you're not called back, if you have a reasonable belief or an expectation that you'll be called back, Even if you're a seasonal employee and even if you take a few months out of the year not to work, there is still a very good chance that you are owed severance. Seasonal employees, just like part-time employees, just like full-time employees, casual employees, even people who think that they're independent contractors, when they lose their job, when they're let go, when they're terminated or not called back after maybe a layoff or after a season has ended, most of these people are owed severance. And so I wouldn't assume in this situation that you're not, Sam, but it may also be one where we've got to collect some more info, get an idea of whether you've signed contracts with these people, maybe if every year you're having to sign a contract or not, and also what kind of discussions were had and how things exactly ended and sort of the expectations around that. But yeah, absolutely, there could be a very good chance that you are owed severance. So don't forget that, and definitely give us a call, and we'll definitely find out and give you some advice on what your full rights and entitlements are. I've got another question in on Reddit from Annie, who's saying that they were laid off the day they returned to work from a maternity leave, and their employer has refused to provide them with any explanation. And Annie's asking, what can they do in this particular scenario? So obviously, if you're an employee and you're coming back from a maternity leave, or you're coming back from a disability leave or a paternity leave, I mean, it could be a number of different leaves that you could be coming back from. But let's say a maternity leave, and your employer terminates you the day you're back. Obviously, a lot of people, if not most people, are going to be thinking, did my maternity leave have something to do with my termination? Was my employer holding off from terminating me during my leave because even they knew it was going to be looking bad, and then just decided to wait until I got back so that potentially I wouldn't be able to use the fact that I was on a leave? A lot of employers, unfortunately, do this and think this way. And if there is even 1% of the reason for why you were let go had to do with being on a maternity leave or possibly having childcare commitments at some point following a maternity leave, then that is going to be seen in the eyes of the law and the human rights people as being a violation of your human rights. And not only will your employer be on the hook to provide you with your full severance, just as in anyone's case if they're let go, but they're also going to be on the hook potentially to having to pay additional human rights related damages. So, of course, employers are never going to admit to the discrimination, and it can oftentimes be an uphill battle and fighting with employers on this front. But as I say, if even 1% of the reason why your let go had to do with something like that, and the optics look very bad from the company's perspective, this is definitely something you're going to want to address with them. And as I say, look for not only your full severance, but additional damages on account of that being a violation. And obviously, it may depend on what the employer has to say, but they're definitely in hot water in a situation like that. But thank you for the question, Annie. I've got another one in from Darwin on Facebook, who's asking whether or not a company can claim to own any of your developed ideas while you're employed by them. And Darwin's referencing an intellectual property clause in their contract, but is asking, what happens if I design software on my own time? And so, Darwin, it's a good question. There are definitely situations where there is an intellectual property clause or a confidentiality clause of some sort in a contract where it may be applicable. So yeah, if you're designing software or you're designing some kind of product, if you're doing that on company time, and especially with company information or tools, then there is a very good chance that sort of product or whatever it is you're developing is going to likely be owned by the company. However, if you are working on something outside of your work hours, if you're designing some software with little or no influence from the company itself and just through information you acquired on your own, nothing really, proprietary that you're using of the company's, then generally, yes, it's going to be a lot harder for the company to claim ownership over those ideas or over those products. Now, as with many things, it may also come down to what the intellectual property clause or contract says. So you're going to want to have a lawyer go through that intellectual property clause specifically and kind of highlight at the very least what the risks are. Because it'll in many cases come down to what's been drafted there. But yeah, generally, I think it has to do with just whether or not you're doing it on company time with company information or tools or products. That's going to cause a more of a connection to what you're developing and the company. And, there could be an issue there. I know a lot of intellectual property clauses will ask you to run something by the company first before working on it, or get their consent to work on certain things. So you may want to be on the lookout for that. But yeah, definitely if you're in a situation like Darwin is, you want to get a lawyer to review the contract, find out at the very least what could be possible down the road, what risks you are at, and then take it from there. But definitely do that before getting too deep into it, like with most things. But thanks for the question, Darwin. I've got another one in from Christina on YouTube. Christina is asking, if you feel that you've been discriminated against at your place of work, how can you prove this? Are companies penalized if they're found guilty of discrimination? So to answer the second question, yes, companies are penalized if they're found guilty of discrimination. There can be a number of different penalties, actually. So I mentioned earlier with the question from Annie regarding maternity leave, that if you are discriminated against, if you lose your job on the basis of, let's say, your age or gender or race or pregnancy status, anything that's covered in the grounds under the Human Rights Code, then your company is going to be on the hook to pay you damages. So apart from your severance, your company could be ordered to pay 10, 20, 30 or more $1,000 of additional damages just for the fact that they discriminated against you for whatever basis. And there are also other penalties that can be imposed on companies who are found guilty of discrimination. Obviously, if there's a finding of discrimination, because companies generally have to have anti-discrimination policies in place, there may be an order that's made by a court, by a judge, by a tribunal of some sort to ensure that the company, have their employees given anti-discrimination training, or that certain policies be posted as a requirement in the office place. There could potentially be other fines levied against the employer, depending on sort of the aspect of discrimination and how it sort of applies in the grand scheme of things. So those are some of the main ways that companies can get penalized. But in terms of how to prove discrimination, that is, I was mentioning before, oftentimes an uphill battle, because a lot of times from my experience, when people come to me and allege that they've been victims of discrimination, oftentimes it is as a result of somebody saying something or doing something, but not necessarily putting any of this in writing. Most people are not going to be stupid enough to be putting clearly discriminatory things in writing, whether it's an email or a letter or whatnot. So you're going to usually be left with having to prove the discrimination based on a he said, she said. I think that because of this fact that discrimination is very rarely a clear-cut thing, it's always good as an employee to make notes yourself. So for instance, if you are in the boardroom on a Wednesday at 6 p.m. and your boss says something discriminatory to you, because they're not going to put it in writing, making a note to yourself at that time or after the meeting, this is the time it happened, this is verbatim what they said, that can be very helpful because there's not going to be that record. So if you can have clear notes that say verbatim what somebody said, rather than a more general allegation of, so-and-so making an age-related comment, the more generic the allegation, the harder, of course, is going to be to convince a company to part ways with money on the basis of them discriminated against you. Because as I say, they're never going to admit to it. So keeping a record of it would be one thing I would recommend. The other thing, of course, is obviously raising this concern with your employer. If you find that your employer or somebody within the company is violating anti-harassment laws or anti-harassment policies or anti-discrimination policies, then you should at least consider bringing that as a formal complaint to your employer, to maybe HR, and having an investigation happen. Now, I would say get some legal advice before doing this, but by actually filing a formal complaint, now you have something on the record. Now you have something that may be seen as more legitimate from the company's perspective. And if they don't take the right steps to address the discrimination, then they can be seen as having dropped the ball. And you've now proven that you raised the issue, they've dropped the ball, and now you even have more leverage. Or they might just be very dismissive of the complaint and say that they don't think it happened. They could conduct a faulty investigation into the complaint of harassment or discrimination. So that's another option, and something definitely recommended at some point is to make the employer aware of it. Because a lot of times these things happen in private, maybe amongst a couple people. It ends up being a he said, she said, and the company ends up saying, we were never informed of this by you. And they try to potentially use that as a reason for not paying you any money or paying you discriminatory damages, because their whole argument would be, well, had you let us know, had you informed us of this, we would have taken the right steps. So you don't want to give them any more leg of stand on if you can. But those are probably the two main things that you can do to help prove or help substantiate your claim. You can also consider possibly recording individuals, although it can get a bit iffy when it comes to people being recorded without their knowledge. That evidence can be used in many cases, even if the other person doesn't know. But it may come down to the situation, whether or not it's reasonable for someone to record somebody else. But those are a few of the main things. And Christina, if there's anything else you wanted to discuss regarding this, then by all means, give us a shout. Again, we can set up a consultation to discuss further. I've got another, actually, Christina has got another question sort of related to what I just said regarding whether or not someone can make a recording of a meeting of somebody. And I think if, let's say, somebody has a habit of saying discriminatory things verbally, and you suspect that they're going to do so again, that could potentially be an example of where a recording would be justified. If somebody is recording somebody else arbitrarily and with no real basis, but maybe just a vague suspicion, that can be a bit more iffy. Again, it's going to come down to each individual case, and probably going to be best to get some legal advice and speak with a lawyer fully as far as whether or not you can use a recording as evidence, even if you have recorded something. Yeah, Christina, hopefully that answers your question. I've got another question in from Marilyn D'Souza, who's saying that their job is seasonal and wondering if they can use banked hours for the period when there's little to no work. And I would say, Marilyn, that may come down to whether or not that's something that's allowed within the business itself. So you may have a policy with respect to banked hours, where you can use banked hours when there's sort of a lull in the work or little work. So it may come down to just whether or not that's part of your contract, whether or not that's a term of your employment, that's something you can do. But it may also involve a little bit more investigation. It also could consider whether or not it's happened before, if you've used banked hours or other people have used banked hours in that scenario, or if you're aware of that being the case in other circumstances, then that might give you a better leg to stand on in terms of doing that. But yeah, generally speaking, would probably come down to each individual employer, what their policy is, and what, if anything, the policy may say. But yeah, again, if you want to talk about it further, Marilyn, by all means, give us a call and we can take you through it a bit more. With that said, and I know there's some other questions still left lingering, that's my time, everybody. I do appreciate all the people who brought in the questions. Hopefully I answered, the ones that I did to their satisfaction. But if there's anything else, feel free to give us a shout, give us a call. Happy to chat, as I say before, regarding any issues that are brought up. And as you see down below there, you can join us again live at 1 o'clock Eastern this Tuesday, which is tomorrow. So definitely tune in if you've got any questions or for those that I didn't answer. And we'll be very happy to answer your questions then. But until I see you guys next time, all the best. Hope you have a great rest of your Monday, and absolutely do take care. All the best. Bye for now.